Good evening, everyone. I'm Kajal Sinha. I'm a trademark attorney working with LS Davar and Company for the past 18 years. Before I start off, I would like to introduce my company in very brief. LS Davar was established in the year 1932, and we have offices in Delhi, Kolkata, and Bangalore. LS Davar is an IP boutique law firm, and we are into assisting clients for filing IP matters in India, as well as prosecution and enforcement. And it includes trademark, designs, patents, copyrights, and GI. So other than in India, we are also assisting our clients for filing, prosecution, and enforcement of their rights in the neighboring countries of Bangladesh, Nepal, Bhutan, Sri Lanka, Pakistan. And we have a young and vibrant team of lawyers who are into this, who have got wide experience in this IP field. To start off with today's deliberation, before I start, I would like to thank WIPF for giving me this opportunity today to deliberate on this topic, trademark dilution, a transnational perspective. Trademark, as we all aware, it's having a distinctive character, and it's again acts as a source identifier. So basically, the aim of trademark is to prevent the consumers from being confused or deceived on the origin of the goods. So is it possible, like, somebody can usurp a trademark? Like Kodak, we know it's well known for cameras. Can somebody adopt Kodak for pianos, or DuPont for shoes, or Microsoft for multimedia? The answer is no. So the well-known brands, when they become globally recognized by individuals, and people tend to associate those brands with a particular goods or a particular range of goods and its attributes, it needs protection. Like Kodak is associated with cameras, DuPont is associated with chemicals, Microsoft with software, and any use other than that, misuse should be stopped. So here, when I'm coming to this concept of misuse, there's a concept of trademark dilution. So misuse may lead to trademark dilution. So as per Black's Law Dictionary, trademark dilution is defined as impairment of a famous trademark strength, effectiveness, or distinctiveness through the use of the mark on an unrelated product, usually blurring the trademark's distinctive character or tarnishing it with an negative association. So trademark dilution may occur even when the goods are not competitive. So we have seen, misuses. Like as I mentioned, if a trademark like Kodak is used on piano, it will lead to dilution of the trademark. So it can happen either by blurring or by tarnishing. So here is an example. Before I move into the example, just tarnishment. So what is tarnishment of trademark? As a term, tarnishment, it is a dictionary word which indicates that, again, some kind of negative image or, attacking on the reputation. That is tarnishment, tarnishing one's image. So tarnishment of trademarks is a form of dilution that occurs when an unauthorized use degrades the marks or diminishes its distinctive quality. For example, like in this particular case, before US District Court, Coca-Cola versus Gemini Rising. Here, the defendants, Gemini Rising, they had adopted the mark Enjoy Cocaine on posters, for posters. And they were preparing they were basically preparing posters with a graphic design which was much similar to, or identical, I must say, to the logo of Coca-Cola, the Enjoy Coca-Cola logo. The fluidic presentation, the color combination, everything was it was identical. So when Coca-Cola brought an infringement case against Gemini Rising, while the court acknowledged that the defendant was not making infringement sales since Coca-Cola dealt with soft drinks while Gemini is attempting poster sales, but the court concentrated, or they observed upon the fact that Gemini was intentionally using the logotype of Coca-Cola to encourage people to enjoy a narcotic drug. So basically that was giving Coca-Cola a negative image, or it was attacking on its reputation, it was tarnishing its reputation. So that is what is tarnishing of trademarks. Trademark dilution by way of tarnishment. In this particular case, again, this Polo trademark, which is very well known. So this defendant, Schumann, they adopted the mark Polo Club, Polo Executive on Adult Entertainment Club. And that tarnished the image of Polo trademark. So this is again a concept. So whenever a misuse is in such a manner that it's tarnishing the image of a trademark, so that is again a manner of trademark dilution by tarnishment. Now, blurring of trademarks, this is again a dilution where the distinctiveness of a mark is weakened by a third party through a completely unrelated, use on unrelated goods. For example, in case Kodak is used by any third party for pianos, or a Polaroid for shoes, or Bajaj for furniture, we'll call that as blurring of the trademark. There is also a concept of free riding of trademarks, by which the third parties enjoy the benefit of positive association with a well-known trademark and its prestige. And it's sometimes referred to as, giving them an advantage. So such free riding will create a confusion in the marketplace and will cause harm to the owner of the trademark. Now, in the Indian Trademarks Act 1999, Section 29, which lays the doctrine of infringement, in Section 29(4) of the Act, we see the doctrine of dilution being laid down, being defined there. So, Section 29(4) says that a registered trademark is infringed by a person who, not being a registered proprietor, or a person using by of permitted use, uses in course of trade a mark which is identical or similar to the registered trademark in relation to goods and services which are not similar. And the registered trademark has a reputation in India, and the use of the mark without due cause, that is the use of the third party's mark without due cause, takes unfair advantage of or is detrimental to the distinctive character or repute of the registered trademark. So Section 29(4) lays down the doctrine of dilution, so when the Indian Trademarks Act is concerned. This is again a very well-known case in India, where the Indian court had recognized trademark dilution. It was in the early 90s when Delhi High Court had issued this judgment in this particular suit of Daimler-Benz AG versus Hypo Hindustan. It was again here when the defendants were using the trademark Benz as we can see, the Mercedes-Benz, the well-known trademark of Mercedes-Benz, and the Tri-Star with logo, which is being copied by this defendant Hyper Hindustan. And here the doctrine of dilution was was used, and the honorable judge here in the judgment had mentioned that, I think it will be a great perversion of the law relating to trademarks and designs if a mark of the order of Mercedes-Benz, its symbol, a three-pointed star, is humbled by indiscriminate colorable imitation by all or anyone, whether they are persons who are making undergarments like the defendant or anyone else. Such a mark is not up for grabs, not available to any person to apply upon anything or goods. So even though the goods are not related, such well-known marks are not up for grabs, and such dilution cannot be allowed. Again, in India, in this particular case of ITC versus Philip Morris, here ITC, as we are all aware, that they are a hotel chain with the chain of hotels like ITC Moria, ITC Sonar in Kolkata, and then ITC Windsor in Bangalore. And Philip Morris, who are the owners of the well-known brand Marlboro, and they are in the cigarette industry. So in the year 2010, it happened that Marlboro, they introduced a festive pack with the M design, which is shown here. ITC alleged that the M logo violates the Namaste logo of ITC, which is very famous. So ITC's primary argument was on the basis of that it was a violation of section 29(4). There was a dilution. So court, while ruling out dilution, had observed that no use of such logo on cigarette packets, that is the no use of the that Namaste logo on cigarette packets, makes the trademark dilution claim raised by ITC non-sustainable. So since ITC was not using that logo on cigarette packets and was only using it for the hotel chains, so the dilution was not, couldn't be sustained. The court further observed that ITC never used a mark on cigarettes, and the fame of the ITC mark could not be extended to mid or high-priced cigarettes, and therefore the trademark dilution cause of action cannot survive. So while recognizing trademark dilution, the theory was it was brought by Frank Skester in the year 1927. He mentioned about the concept of whittling of distinctiveness, dilution theory with whittling of distinctiveness. In 1996, in USA, a separate act, that is a Federal Trademark Dilution Act, was introduced, which defined dilution as lessening of the capacity of a famous mark to identify and distinguish goods and services. So according to the US trademark law, for a dilution, the mark necessarily has to be famous, and a mark which is not highly distinctive cannot be diluted. So after 1996, the law was was revised, and the Trademark Dilution Revision Act (TDRA) of 2006 came into place. So that was a specific legislation which was dealing with trademark dilution in US. So even when we go through the US case laws, like in this particular case of Nike Inc. versus Nike Pal Intern INC, Nike, who are well known for shoes, apparel, and sports equipments, and Nike Pal, who were using the mark for glass syringes and other laboratory goods and were into services since 1998, whereas Nike's mark was used much way back prior to Nike Pal. In this particular case, what happened is the court believed that the marks in dilution analysis must be identical or nearly identical. So court here again took into account a survey which showed that majority of the survey respondents representing a significant segment of Nike Pal's target customer group associate Nike and its products and services when they encounter Nike Pal, thus perceiving that the two marks are essentially the same. So here again, it was perceived that the marks are identical and hence there was an injunction issued. But in this particular case of Starbucks Corp versus Wolfsboro Coffee, the Second Circuit Board, they abandoned this approach. Now, this company, Black Bear, they were basically a company engaged in the sale of coffee products, and it was a family-run business. And Black Bear was selling a dark roasted blend of coffee under the mark Charbucks Blend and Mr. Charbucks. So to this, which was nearly identical or similar to Starbucks, Starbucks demanded that Black Bear cease use of Charbucks marks. So they filed a complaint before the district court alleging dilution and infringement. But court here considered that there is no likelihood of confusion between the products of the plaintiff and the defendant. The plaintiff must prove a probability of confusion and not mere a possibility, affecting numerous ordinary prudent purchasers in order to establish a likelihood of confusion. So given the prominence of Black Bear on the Starbucks products, that is, Black Bear was much more prominently placed on the products, and the conspicuous differences between Starbucks marks and the Starbucks marks as they are presented to the public, it was not clearly erroneous for the district court to find that the two marks were only minimally similar. So the dilution factor was not given consideration, rather that approach was abandoned in this particular. Dilution in Europe, I'd like to discuss about one important and first trademark dilution case in UK, where a similar situation was being dealt with, and the defendants were trying to put the reputation of the plaintiffs in a negative light. So in this particular case of Eastman Photographic Materials Company versus John Griffith Cycle Corporation, the plaintiff sued the maker of Kodak bicycle. So Eastman Company, who are the the proprietors of the trademark Kodak for many years and for the goods photographic cameras, so they were also making cameras suitable to bicyclists and of appliances for fixing the same to bicycles, and where they were advertising it as bicycle Kodaks. The defendant, what they did is they obtained registration for the mark Kodak for bicycles and other vehicles included in that class, and they registered the mark and also registered the company name Kodak Cycle Company Limited. The plaintiff sued them to restrain the defendant from carrying on business under the name of Kodak Cycle Company Limited and from passing off their goods as goods of plaintiff and from infringement of the trademark of the plaintiff. So it was held that the word Kodak has become identified with the plaintiff's company's goods, and the evidence showed a connection between bicycle and photographic trade. So it was found that the defendants were trying to get benefit of the reputation of the plaintiff company, and the trademark must be expunged as being calculated to deceive, and the defendants were restrained from trading under the name of Kodak Cycle Company. So initially, it would seem there is no connection between a photographic camera and a bicycle, but the court held that the use of the word Kodak in connection with bicycle was calculated to lead the public to suppose that the cycle company had connection with the plaintiff company, which sold Kodak for cameras and other equipments, as I mentioned, for bicycles, and they were advertising also. So after going through the case laws for US, in US and Europe, as well as I discussed the cases of Daimler-Benz as well as ITC versus Philip Morris. So for the doctrine of dilution, considering an ended context, I would like to say that it's still a little unclear whether a mark which has reputation in a particular sector of the public or only in a particular area within India would be entitled to protection from dilution within that sector or area. So I'd like to make an observation here that the courts across the globe have found it difficult to distinguish trademark infringement from trademark dilution. And rather than fighting this trend, the legislatures and the courts ought to embrace it. Like the likelihood of confusion standard ought to be expanded to encompass dilution. So with this, I'd like to end my presentation. Thank you very much, everybody, for giving a patient hearing. In the event you have any question and answers, you can put them forward. Thank you so much.